Okay, so we are on lecture 7 today, looking at land registration in a bit more depth this week. So this is a situation where people have the ability to tell the world at large that they exist, and we've looked at some principles of registration and some ways in which people can enter into the register. We'll look at that in a little bit more detail today, and then look at how we can move from recognition of registry as a mirror reflecting those rights to articulating there are some situations where it's not possible to fully protect every single situation, and to recognize that there would be a complete registration of every person and every party. So that recognition of a crack in the mirror that we will get to today. So we'll look at the mirror principle very briefly. We will look then again at how to attach those people to the land. Remember, as if they're a bathroom fixture, as if they're a bath that comes with the property. If we can attach those people onto the land using the right document, as we have previously, and now using registration, they are affixed and attached and become part of the land as well. We'll have a recap on how they become visible. So how do they reflect if we're looking at the mirror of registration, and then consider situations where it's not possible to articulate or identify their existence on the register. That then moves us into another area within registration called overriding interests, and we will do a whole lecture together in lecture 8 regarding overriding and overreaching. So overriding interest is a party that can override the new purchaser because of their interest that wasn't registered. Their interest will override that of anybody else coming to the land, so they're quite a key party. And we'll look at that together. So we've already recognized this idea of a mirror principle, that the register should act as a mirror and reflect back to the new purchaser exactly what the land looks like, what they're getting, who's attached and affixed to it, what benefits come with it, and what restrictions it may be encumbered by. So all of that matters, and that's the purpose of the register, is to provide that form of a reflection, reflect back the truth of the land itself. We've looked at forms then of entry onto the register. So we've looked at the fact that there are certain dispositions that have to be registered. Those registrable dispositions, meaning that it is for those parties to protect themselves in that way by entry on the register. They have to obviously do that. Thinking then about a notice as a way to allow for protection of certain rights or interests in or over the land, usually beneficial in nature. So some form of equitable interest is usually protectable through notice. So registrable dispositions, mostly legal. Our notices are mostly equitable, but that's not kind of 100% true. If you're looking at your 4-box method, there are some exceptions still. The restriction then being the method where if you can't enter a notice, you may be able to restrict or fetter the true owner's ability to deal with the property in some way or to pass it on free of you. So you could restrict the true owner's ability to pass on without your say-so. Usually beneficial interest under a trust would be advised to behave that way, and definitely the bank behave that way, because they're the ultimate party who can restrict the true owner's ability to behave like the fee simple absolute possession holder that they are. So these entries, these forms of entry, are very easy for anybody else coming along to the land to identify. A conveyancer doing searches will see these people. They will appear to the world at large. Their entry will be visible, and that makes for a very pleasant and easy transaction. And then the difficulty arises where these people should have behaved that way and haven't, or where they couldn't behave that way and there was still a crack in the mirror. So that's the journey we're now going on together. We've already covered these situations where there is a registrable disposition that has to be entered onto the register. So every time we have the transfer or sale of land, we have to register that. We have to recognise who the fee simple absolute in possession holder is. We have to be able to recognise a long-term lease above 7 years, as that leaseholder will have that absolute hold over the land, so they also must be registered. The legal lease beginning 3 months after grant is a mechanism to allow for people to protect themselves if they know they're not going to be taking occupation, but they have signed a lease. So if they've signed an agreement that commences 3 months after it's been given, then they won't be in the property physically. They won't have their things around to articulate or identify their presence and to protect their interest. So the only way they can physically manifest themselves somewhere would be to appear on the register. The express grant, so given or reservation kept back of a legal easement, is also a registrable disposition, and we will look at that in more detail when we get to easements. And the grant of a legal charge or rent charge, which you should now become comfortable with this idea of a legal charge meaning a mortgage. So a legal charge being a charge over the land, the interest on it is charged by the bank in return for money. Rent charge we won't have to look at in any great detail. So anyone coming along to buy the land is subject to those dealings. They have to be articulated and identified on the register. If people haven't protected them on the register, then their interest is void. It has to appear there. And as it says, apart from the fee simple absolute in possession holder, which would appear up on the proprietorship part of the register, all of the others appear down as charges. So the key focus for us usually will be quite easy for us to articulate the identity of the fee simple absolute in possession. They will be the party who will be listed in the proprietorship section of the register. The registered charge we've already looked at as some form of mortgage, either a first mortgage or a subsequent mortgage on the property. That means that the interest in the land is reserved by the bank in return for money. As I said, any mortgage is possible, and it becomes a legal interest, which we already know under section 1.2c for the first mortgage, 1.2d for any future legal charge. In order then to be legal, apart from the requirement for a deed that we know is the documentary evidence we would need, it also has to be registered under section 27.2 F of the Land Registration Act 2002. That's the key element that affixes and attaches that charge to the land itself. That's the thing that makes it proprietary in nature. Rather than just a personal conversation about a loan, it becomes a land law matter by being affixed and attached to the land through registration. It will then appear in the charges area of the register against the freeholder or the leaseholder's title. So it is possible to secure mortgage against leasehold title. Remember, we might have those 99-year leases, those incredibly long leases that of their nature are of value, and there could be a mortgage held against them as well. So we've already looked at this, and we can see down in the ringed red circle there, registered charge dated 30th December 2001 to secure monies. It won't refer to the amount, but it will refer to the mortgage monies, including the further advances therein mentioned. So if there are going to be any future advances and repayments, etc. So this appears in the charges aspect of the register, and that articulates interests affixed and attached to the land. It doesn't give the full deed of the mortgage, but it does, and it doesn't refer to the terms of the mortgage, but it does register the bank's interest and hold over the land. So after a registrable disposition, such as the registered charge, we will have the ability for other parties to show in that mirror, that reflection of interests in the land, that they exist, they have some sort of hold. Notice is a form of entry on the register, and it does relate to some form of burden that affects that estate itself. So it does kind of burden or hamper the use or the ability of the fee simple absolute and possession holder to behave in a certain way. So that's the idea of it. It gives notice to the world at large that there is this hold over the land, there is this party who has an attachment or a fixation in some way. So that acts as a form of notice of their interest in that legal estate. It tells everybody that they are able to encumber in that way. Again, if you remember where we were a moment ago looking at the charges register, above the mortgage itself there was a covenant, so it's entered into the same part of the register. It's entered into the charges place as well, because it's another thing that fetters or restricts the estate in some way. So it's restricting the estate, not the person, so it's against the property. It then will also bind anyone else who comes along to take that property. So we're looking at future use as well. We're looking again at something that affixes, attaches, annexes to the land. Just like tree roots, it secures them to the land. And it binds anyone who comes along to take it in the future. Section 29, Section 30 of the Land Registration Act are your authority for that. So what happens is the entry will be made to the registrar. It could be of any different form of interests that are held. So it could have been some of those interests under Section 27. So a legal easement might be entered, an equitable easement might be entered, a restrictive covenant could be entered, an estate contract or an option to purchase, so that promise to buy land in the future. The right to occupy the property as well can be entered. So we've got all these ways, so that's the spousal right to occupy or the civil partner's right to occupy. So we've got all these interests that encumber, affix and attach to the land, usually promissory in nature. The exceptions in Section 33 being important, so there are certain situations where people can't give a notice, and we looked at that previously, we'll look at it again. So say for example restrictive covenants, those don't refer to landlord and tenant covenants, they're just freehold ones. The right of occupation is able to be protected by notice, but a beneficial interest isn't. Lease between 3 and 7 years could be entered by notice as well. So but a lease under 3 years couldn't under Section 33. So an entry by notice is a way for certain parties to be able to tell the world at large they have this hold over the land. And then we would look at Section 32 in connection with Section 33, thinking whether some of them aren't possible actually to be entered on the register. So the exclusions that I've just mentioned under Section 33 would be a beneficial interest under a trust. So unless the person who is claiming a beneficial interest is a spouse or a civil partner, they would not have any protection under Section 32. Section 33 would disallow them from entering a notice just purely because they're a beneficiary. If you remember back to our example of Yvonne previously, Yvonne's payment to her daughter of some money towards the purchase price and her living there, well, she would not, if we look back, fall under the right of occupation that could be protected by notice through the Family Law Act 1996 because she's not a spouse, she's not a civil partner, she is a parent, and in that capacity she falls to being just a beneficiary, a beneficial interest under a trust of land, which means that she cannot enter a notice onto the register. A shorter term lease, so a lease under 3 years, could never be protected by notice. So if it's over 3 years and under 7, it will be able to be protected by a notice. If it's over 7, it has to be registered as a registrable disposition. If it's below 3, it cannot be entered on the register, and we can see a crack in the mirror there. We have somebody that we know could be on land, could have a strong 2-year lease that entitles them to absolute hold of the land for that 2-year period, that term of years. We know it fetters and restricts the true owner's ability to hold the land. And we know it gives that tenant rights of security and hold over future purchasers. But a future purchaser coming to the land, just looking at land registry, will not see them. They will not appear. Because they can't enter a notice, so there's no way for them to have a foothold on the register, and that's really important. It's really important to know that it's not just a situation where a husband or a wife or a cohabitee could have protected themselves and didn't, as in a civil partner or a restriction, which we're about to look at in a minute. It's not that somebody could have protected themselves and didn't. There's actually no way for somebody who holds a short-term lease to ever appear on the register. It's impossible. It's a big crack in the mirror of land registration. So that is significant for us if we're thinking about people who could be on the land, could have a legal estate because it's a term of years absolute, but they don't appear on register. As we've said, restrictive covenants could be a notice, but not the ones that go between a landlord and a tenant. Those types of covenants are not able to go into a notice. It binds those two parties, it doesn't bind to the land. So those are the main exclusions that we're going to cover in terms of this module, the sorts of people who we might come across on land, but we can't enter them as protected through notice for some of these exceptions or exclusions. In thinking about what that party does then, we have a system in place for the party who feels they have an interest that affixes and attaches them to land, and we can have an agreed notice or a unilateral notice. An agreed notice would be where, as it says there, the applicant is the fee simple absolute and possession holder, so the proprietor applies or is part of the process of application. So if there's a covenant attaching to the property, the true owner will get in touch with Land Registry and apply for this covenant to restrict any future uses of the property. Same with the right of occupation. It's going to be in agreement that those two parties who are married or have a civil partnership will want to protect that relationship and enter a notice into the register to tell the world at large that that's what's happening. Where there's a unilateral notice, it's the party with the notice who will apply to Land Registry. This is usually some form of charge. So this is usually where the interested party might want the hold over the land, and the proprietor will then just have to accept that that's the way it is, and will probably be accepting on the grounds that they have a form of paper that says that they are bound to accept in that way. So, for example, the bank who are placing the charge upon the land will apply to Land Registry to become the registered just registrable disposition of the charge. They will also apply for a restriction, which we'll look at in a moment, and then the registrar will just tell the owner that that's what's happening. Okay, so there's either an agreement between the owner and the party who want to be on the register and they apply together, or the freeholder applies on his or her own. And then we've got the other situation where it would be the party who's got the interest will apply, and the registrar will just give notice to the proprietor that that's what's happened. Okay, so moving forward into looking at restrictions. I know some of this is very tricky to get your head around, but we're only going to look at restrictions as being used in two key ways. So you need to understand that a notice is an ability for the world at large to see that somebody's right exists and have that information, have that reflection of the hold they have over the land. There is notice of a burden attaching to the land in some way. A restriction is placed upon the owner. So a restriction is fettering the true owner's ability to behave in a certain way. It's usually some form of condition that the owner has to meet in order to pass the land on to another. So they're on subsequent disposition, on passing it subsequently at a future date, passing it on to somebody else, there will need to be some condition met. And the purchaser, so the new purchaser, needs to make sure that the condition is complied with, so as to ensure that if there's a party who restricts or fetters the true owner, that they are aware of it, they comply with it, they ensure that that mortgage is paid off, or that overreaching has happened, for example. And I'll look at overreaching with you in more detail, but it's for the purchaser therefore to articulate and identify what that restriction is, because it's restricting the true owner's ability to pass freely to them. So they have to be aware of it and they have to ensure that the condition is complied with that restricts that true owner's ability to pass. So if we're thinking about the Tony and Bruce situation we had in the fixtures and fittings scenario, Tony was selling the Stark mansion to Bruce. If Tony had a restriction against him as a person, a condition that had to be met by him personally before he passes the Stark mansion on to somebody else, then Bruce would see it on the register and have to ensure that that was met before he could take it freely. And that's a job for the conveyancers to ensure happens above their heads. So what type of conditions might somebody be put under? The main one that we will have thought about previously would have been for a bank who have lent money in return for a mortgage against the property. The main restriction would therefore be to pay the bank back their money and then you can pass it freely. That's one restriction. So the bank have the ability not just to fetter the land with a charge, but also fetter the true owner's ability to pass on freely of them. Like I've said to you before, the bank are the only party who can put themselves on the register twice in two key areas. One's attaching to the land and one's attaching to the seller or the fee simple absolute in possession holder. There is another way, however, where a restriction could be placed by a beneficiary under a trust. So the beneficiary under the trust, such as Yvonne, the mother in the other example we had, who'd given money to her daughter. Yvonne couldn't enter a notice because Section 33 said she wasn't able to. Yvonne, however, could enter a restriction. It's not enough for Yvonne to say to the world at large that she exists, however. It's not enough. She will need to ensure that she has put conditions in that protect her. And that's where we're headed in the next lecture. We're going to look at a thing called overreaching, which is a way to take Yvonne out of the property by paying money across to two parties. So without kind of boggling your mind, it would be possible for us to see that Yvonne exists, pay the money to two people on trust for her, and take her out of the property. Obviously, if the person selling the property over her is already untrustworthy and then asks their brother, sister, new lover, whoever to be a new trustee, then Yvonne's likelihood of getting that money is very limited. So it would be in Yvonne's best interest for her to place a condition against the party stipulating who she wants that money to go to. Who does she trust to be the two trustees that money goes to if she's going to be overreached? Now, I know it's very difficult for you to think about how this would work when we haven't covered overreaching yet. We're going to be doing overriding interests and overreaching all through the next lecture. So just hold that in your mind, that it's possible for payment to be made to two people on trust that those two people would protect her. Obviously, if they're not trustworthy, that might not happen. So the condition that she could place on the register is not just that she exists, but where she wants that money to go so that she's protected. It could also be a condition that the mortgagee has to have consent before selling. So this is the bank, for example, could require consent of the bank to sell. Because if you think about it, if the sale's not going to satisfy their mortgage money release, if it's going to be negative equity, they won't consent. So the bank aren't just attached to the land, they're attaching themselves to the seller by saying, if you sell this property, you've got to make sure that you can pay us back in full. And that will be the thing you'll have to do to satisfy us and pay and pass the property over to another party. If someone still owes £130,000 on the mortgage and the property's only worth £110,000, the bank are unlikely to consent to the sale unless they have some form of provision for the other £20,000 being paid in some way. So you can look at this example of the proprietorship register. So as I say, this is against the person. This is against the fee simple absolute in possession holder. Here we have Jacob and Jane as the true owners. And the restriction placed upon Jacob and Jane is that no disposition, so no passing it on by a sole proprietor by one of them, under which the capital money arises is to be registered unless authorised by an order of the court. So we have a situation there where they're both very clearly tied together in this. It's not possible for one of them to be able to pass it on unless there is a court order saying that that's what is to happen. Okay, so that would stop either Jacob or Jane being able to be the sole passer of the estate. The second example we see there is where Peter and Susan are exclusively in ownership of the land, and the restriction that's been placed upon them is that except under an order of the registrar, so the registrar at land registry, no disposition by the proprietor of the land, so that the owners of the land, is to be registered without the consent of the proprietor of the charge, dated 2001, in favour of the building society related to in the charge register. It's exactly what I said there. In terms of the bank's interest, the bank won't allow the property to be passed over to somebody else unless they have consented to the sale of the land, and that would purely be about satisfying themselves that the money that they lent can be returned to them. So that's a way for us to articulate or identify these people that affix and attach to the land. We've looked at registrable dispositions, the people that have to appear on the register and protect themselves. We've looked at notices as a way that people can protect themselves and are definitely advised to protect themselves. And then we've looked at restrictions being really subject to two key parties: beneficial interests under a trust, or banks who want to protect themselves in some further way by not just appearing down on the charges part of the register, but fettering and restricting the ability of the fee simple, absolute and possession holder to do something without their say so. Okay, so that is what should happen in terms of a reflection. We should be able to go to land registry and have a true reflection of the land, see those parties there. The dispositions, the notices, the restrictions should all appear in their relevant part of the register. That allows the person coming along to buy the land to know what it is that they are getting with it, what they're burdened by, and what value there is in it. However, we've already established that there are cracks. And the cracks appear where either parties should have, could have put themselves on the register and haven't, but may still have some form of protection. Or there was no way they could have protected themselves because, as we've seen for a short-term lease, there was no registration mechanism for them. That means that the mirror is cracked, and that when we look at the land, there may still be parties there that we don't know about. So we find the crack by knowing what is happening with the land itself and being able to have conversation or dialogue around that. Who's there? Why are they there? Are they going to go? Is primarily it. We also have evidence of protection still for them under Schedules 1 and 3 of the Land Registration Act 2002, and that's what we're going to focus on a lot in the next lecture. These people that are protected still through these mechanisms, even though they could have or sometimes even couldn't have put themselves on the register, they will still be protected in some way. The protective mechanism for them is called overriding interests. Their interest overrides that of anybody else coming along to the land. They affix and attach, just like tree roots, whether they've registered or not. So these are interests that have been unregistered. Well, I should have said whether they could have registered or not. So they haven't registered, and they override either first registration, so that the first time ever that land is going to be registered under Schedule 1 of the Land Registration Act 2002, or where the land is already registered and it's going to be passed on in some way. In the future, Schedule 3 will articulate those interests which override. So they don't appear on the register, but they obviously still do bind a purchaser because they override. They affix and attach to the land like tree roots. Therefore, there still is this element of detective work that goes on, where land registry was meant to make a very complex system systemized and less cumbersome, less costly. We still do have an amount of detective work to conduct as conveyancers. So there we go. Those are the overriding interests under Schedule 1 and 3 of the Land Registration Act. We've got Schedule 1, the interests which would override the first ever registration, and Schedule 3 being the interests which override any subsequent disposition. So focusing just on Schedule 3 because they're pretty similar, and we'll mostly be looking at registered land already in existence. We've got a lease not exceeding 7 years. So, to recap, if it was over 7 years, it had to be registered under Section 27 of the Land Registration Act. If it was under 7 years, it could have been entered as a notice under Section 32. However, if it was under 3 years, it could not have been entered as a notice under Section 33. So Schedule 3 is a way for that interest to still be recognised and exist and override future purchasers. If someone has a lease under 7 years, whether it's under 3 years or under 5 years, they will have an interest that overrides. They could have entered themselves onto the register if it was between 3 and 7. If it was under 3, they couldn't have. But irrespective of any of that, they still have an interest that overrides. Interest of person in actual occupation of the land. So that's somebody who's living there or has some form of permanence in occupation. We'll look at those. So they are people who aren't just living there, sleeping in a doorway, but they have some form of interest or hold in the land. We'll look at that and the exceptions in the next lecture. Legal easements, profit-à-prendre, so those situations where people are allowed access to the land or are allowed to take something from the land, again with exceptions. We will look at that in more detail. So these are people who have long-standing easements and they're implied through long use. We will look together at that in a lot more detail. And then there are other miscellaneous rights, mining, etc., that are encumbered under Schedule 3. So Schedule 3 is something that we're going to focus on a lot in the next lecture. These are the crack in the mirror. These are people who could be on the land, living there as a short-term tenant, as a wanderer, whatever they are, as being on that land and having that hold in it, but they don't appear on the register, and we still have to find out about them because they will bind a future purchaser. So that's why it's important for the purchaser to look at the land whenever they are there, to ask questions and to do their own homework, to ask questions of the seller, to make inspections of the locus of the land, and if you are dealing with a single person, one person, you're seeing family stuff around, that you're having a conversation around that. But ultimately, a lot of it has been made easier through this form. So there's a form that is sent out, TA6, and it's got an awful lot of questions on it. I think it's about 20 pages long. I'll look at it with you in a minute. But it's got this really, really long document that inquires of the seller a lot of detail. So we've already looked at the form that is sent out, listing the contents and whether something might be coming with it or staying, the fixtures and fittings aspect of it. But this other form asks detailed questions too. So let's just look at the TA6 together. So question 11, I'll flick to the top of it in a minute, but question 11 being specifically pertinent to what we want to know today. Does the seller live there? Does anyone else live there? Please, so yeah, an adult. Please give the name of anyone else who lives there as an adult. Are those people tenants or lodgers? Are they going to be gone? Is the main one. Is it being sold vacant? Have these people agreed to leave? Have they agreed to sell it if their permission is required in some way? Please give some evidence that it will be vacant. So that's requiring really that this person who has an interest in actual occupation of the land will be gone when the property is sold. So that TA6 form is vital in passing over responsibility for truthful nature of that to the person selling the property. So it's the Law Society Property Information Form that gets sent again to the seller by their solicitor, asking them to fill in this form, and again articulating that it becomes a binding form of the contract. It becomes something that they are subject to. So things like boundaries, disputes, if there are any disputes, notices, planning, understanding, guarantees for any of the work being done, insurances, environmental situations, any informal rights around road use, access, rights of light, minerals, services, parking, any other form of charges against the property, occupiers, services, heating, draining, sewage, utilities, transactions, etc. So yeah, 18-page long document that has to be filled out with a truthful representation of the knowledge of the seller passing across to the vendor, passing across to the purchaser, sorry. So we can see that that helps in our detective work of ensuring at least the seller is asked those questions. So what I wanted to do today was just look at that idea that the register is a mirror, and that we should be able to look at the register and see these parties on there, that that attachment by them of that interest to the land is as strong as tree roots. Registrable disposition notices and restrictions will fetter the land itself as well as possibly the true owner, and there are visible entries that appear to tell the world at large what's happening with that land. However, we're starting to see and consider the fact that there is a crack in the mirror. We're articulating those interests where people could have put themselves on the register or may not have been able to put themselves on the register and are still protected in some way by Schedule 3 of the Land Registration Act 2002. their interest will still be seen as being valid, and a new purchaser will still be bound by them. So that's where we're heading in the next lecture. We're looking at overriding interests, how to know about a problem and effectively deal with it. Thank you.